Whether you are a permanent resident or not, you can be placed into removal proceedings. And in this video, I want to discuss how you would know if you have immigration court or are placed into removal proceedings. The way this process begins is through the issuance of a notice to appear. We call it an NTA. And the notice to appear explains exactly why you are removable or why the government believes you're removable. Doesn't mean you're actually removable for those reasons. You can challenge it and have the Department of Homeland Security attorney prove the allegations before a judge actually determines that you're removable. And then the next step would be for you to apply for a defense from removal. Oftentimes, people receive these notices to appear by hand. You might be detained by ICE temporarily and then released with a notice to appear in immigration court. If you're a permanent resident and you leave the US for too long, when you come back in the airport, the customs officers can generate a notice to appear and give it to you. Sometimes you receive notices to appear by mail, but that assumes that the Department of Homeland Security has your correct mailing address. So a lot of people also apply for benefits, for example, a green card. And if the application gets denied, they're placed into removal proceedings. And the strategy there generally is to refile a new green card application as soon as possible if you believe that you can get approved. And before I file that new green card application, I check to see if my client is in removal proceedings. And the way I do that is I go to Google and I type EOIR case status. And the very first link is for the EOIR automated case information website. You click that link, it's a public link, anyone can do this, you don't need to be an attorney, and it'll bring you to a webpage that asks you for your alien number. You can find this A number on your green card. It's called the USCIS number on the green card and on work permits. If you don't have either of those, and you're just purely a non-immigrant, like for example, you're on a student visa, it's gonna be way harder to figure out what your A number is. That's beyond the scope of this video. It is possible, but beyond the scope of this video. So anyway, when you're on this website, you just input your A number, and when you click submit, if it says like no case found or A number is not in the system, I forget the exact words, but it's little red text right under the A number, then you know that you are not actively in removal proceedings. Now, it's actually not super uncommon to receive a notice to appear, which means the government is beginning your deportation. And then when you put your A number into the EOIR case status page to see when your first court date is, it might say like no case information found, that red text underneath the A number. What that means is that ICE sent you the notice to appear, but has not yet filed it with the immigration court. And I've seen people in the past, this is less of an issue, less likely to happen today, but in the past, I've seen people receive a notice to appear, and for like 5 years, their case is not showing up in the immigration court system. And that means they are not actually in removal proceedings. And then eventually they're placed into removal proceedings. So if you ever receive a notice to appear, or you just want to check right now to see if you're in removal proceedings, you would go to this website, enter your A number. If you are in removal proceedings, a whole page will show up that says where your court proceedings are. If you have a future hearing date, it'll tell you the future hearing date. If there's an immigration judge, it'll tell you the name of the judge, and then you can look up the statistics of that judge to see, relatively speaking, at least with asylum cases, if they're a good judge or bad judge. These are things I usually do during a consultation with somebody to just figure out where they stand, what the chances of success might be. And if it's just like a permanent resident, or rather somebody who's applying for permanent residence and they got their I-485 denied, or someone who recently had their I-751 to remove the conditions on their residency denied, the first thing I do while we're talking is in the background, I check to see if they are in removal proceedings. I also do this for people who just have complicated immigration history to see if they were ever, and by the way, it's not super uncommon for me during a consultation for someone who's like been here for 20 years and used to have a work permit but no longer does, but can't tell me exactly how they got it. Some like shady lawyer or legal service provider filed for some stuff and they got a work permit. It's not uncommon for me to check the EOIR case status and have to unfortunately inform them that they have a removal order and they've had one for years and they never even knew about it. And then the conversation quickly turns from, how do I get a work permit again, because this other lawyer got me a work permit, to how do I try to reopen my removal proceedings to fix this old deportation order. The consultation takes on a whole new level of urgency when that happens, and it's quite unfortunate to explain to someone that, hey, the reason you got a work permit is because this other guy filed an asylum application for you, which got you a temporary work permit, and you just never showed up to your asylum interview. Either they never told you about the interview, the provider that you used, or you changed address and immigration sent you an interview notice and you just never showed up. It eventually got transferred to court. You never showed up to that either because they didn't have your address. And now you have a removal order, and now your situation is like an emergency because you are a priority for deportation unless we can reopen this. And to make matters even worse, since this happened a few years ago, our avenues for reopening this right now are really limited, and probably no avenues to reopen even exist. There are exceptions, so always speak with an attorney. For example, one of the main exceptions is if you never received notice and you received what's referred to as an in absentia removal order, we might have a clear pathway to reopen your case in that situation, but it's fact specific. I usually need to start by doing a Freedom of Information Act request to prove that you never received a copy of any of the notices that were mailed out. And then we have a chance depending on which judge your case was in front of. I know there's a lot of fear out there right now, so if you're just wondering, am I in removal proceedings? My case got denied a few months ago. I have a new case pending because we immediately refiled. Should I be worried? Click the link. I'll put it in the video description below. It brings you to the EOIR automated case status website, but if you don't want to go to the video description, you could just Google EOIR case status and click the first link that shows up, enter your A number, and you'll quickly find out if you are in removal proceedings. You know, anyone can do this. You don't need to be an attorney. Anyway, guys, I hope this helped somebody out there. If you are interested in speaking to an attorney for any family-based immigration issue, naturalization, removal of conditions, or removal defense, you could always contact my office. My information for consultations is in the video description below. I handle cases nationwide, and I'll see you guys next time for another video.